Good morning, everybody, and welcome to the latest in our In-House in Focus sessions. I'm Mark Pearce. I'm the head of IP at Milton Reeve, and I'm going to talk this morning about IP in the new year and what's happening to European rights post-Brexit, and what you need to know about your rights and whether there's anything you actually need to do. So, you'll have probably heard the language, the voice at the beginning saying the meeting was being recorded. There will be a recording available afterwards. So if there's anything you want to run back and listen to again, it'll be there. If you've got any colleagues who it would be useful to, the recording will be available. If you have any questions, please do ask. There's a Q&A box at the bottom of your screens. If you use that to send questions in, I can pick them up as we go along, or more likely at the end. And then finally, please do take the opportunity to feedback on the session, what was good, what was bad, how well it worked. And if there are any other topics you'd like us to address in these In-House in Focus sessions, please let's have your thoughts on that. We're always looking for questions that our clients want us to tell them about. So, IP post-Brexit, what do we need to think about? Well, the first thing I'm going to talk about is what's going to happen to existing registered rights in the community, and also what's going to happen to any ongoing applications that there may be on the 1st of January when the transition period comes to an end. There are also some unregistered European community rights which we need to think about, and what's going to happen to those, and then how might they be replaced in the UK. I'm going to talk a little bit about steps that you might need to take if you haven't already taken them in respect of your rights. And finally, look at some of the other issues that there might be that arise, and in particular, and the slightly painfully punny title of the talk, I'm going to look at the exhaustion of rights, which is a little unclear and maybe an issue for companies or businesses that trade with the community. So, the first of the registered rights I'm going to look at is EU registered trademarks. And actually at this point, I think we'll use our first poll. So if we could put the first poll up. So, of the people in the listening, can you just answer simply yes or no, whether your business currently owns any community intellectual property rights, that's European trademarks or community design rights? It's a bit more decisive than the US electorate. We appear to have almost 3/4 of the people in the webinar, so 70% now, do have some community rights. And given I know there are a couple of advisors in as well, that suggests that actually a pretty strong majority of you do. So in that case, let's have a look at the second poll, please. So again, I'm going to guess that the answer to this is going to be vastly yes, because if 70% of you have got registered rights, there'll be those that trade in the EU that don't have. So yeah, very strong. So what that tells us very clearly is that these are questions that are important for the majority of people. So that's good. If we could remove that poll from the screen. Wow, 86% is a very strong number. So could we just lose the poll there? Great. Okay, so of those rights, we didn't ask actually to distinguish between EU trademarks and community registered designs, but I'm going to work on the basis that actually the majority of those, if you've got designs, you almost certainly have trademarks. So what's going to happen to your European Union trademarks from the 1st of January? Well, from the 1st of January, they will cease to apply in the United Kingdom. However, as has been agreed in the withdrawal agreement, and the IPO is going to create what is going to be called a comparable UK trademark for every European Union trademark. That comparable UK trademark will be recorded on the UK register. It'll have the same legal status as if that mark had been applied for and registered under UK law. It'll be given the same filing date as the European Union trademark had, and to the extent that that application, that original EU trademark claimed priority date or seniority date, it'll be given the same priority date or seniority date, but it will be an independent UK trademark. The only, we have a question already. No, we don't actually. It's a colleague telling me he's here. Thanks. It'll have the same, it'll be treated as independent. The only issue you need to be aware of there is if the parent EU trademark is revoked at any stage post the 1st of January, then so will the UK mark be, unless the grounds for the invalidation of the European mark are grounds that wouldn't apply in the United Kingdom. So there is still a danger of a challenge to the European trademark, which is the parent mark, leading to the loss of the UK mark, unless that UK mark couldn't have been challenged in the EU. So I've got a question about duplicate rights, and actually that's a really interesting question. I guess if they're completely duplicate, so if you've got an existing UK registered trademark which has exactly the same specification as your European Union trademark, then you will have two identical trademarks in the UK. Now the question as to whether you would want to allow one to lapse, I guess firstly, you don't need to do anything until renewal comes up. On renewal, if they have the same priority date, then I can't see any reason to keep both of them going. If one of them has a later priority date, then you may want to keep the earlier priority date. I guess I'd wonder why you get to a situation where you've got an existing EU trademark and a UK trademark with the identical mark and identical specification, because you effectively had duplication already. But yeah, you I think should take advice, but I suspect the answer is yes. Allowing one of them to lapse would be a sensible move. So let me go back to that slide. And you'll see there's no need to apply for this to happen. It's going to happen automatically. There's no fee to be paid. You won't get a registration certificate. There is an option to opt out, and you might want to opt out if, for instance, you've entered into a coexistence agreement previously, and the existence of a separate UK right might offend against that coexistence agreement. I think the situations in which businesses are going to want to opt out are probably relatively rare, but we shall see. So if you've got an existing application for an EU trademark which hasn't yet been granted, the situation is slightly different. There will be no automatic comparable UK application, and nothing will happen automatically. You'll be given a 9-month period in which you can apply for in the UK for similar protection to that applied for in the EU. But you'll have to pay an application fee if you want to do that. There'll be separate UK examination and grant, but your UK application will be able to claim the earlier EU filing date. So if you've got existing applications going for EU trademarks, you are going to have to decide whether you want UK protection as well. I'm assuming, certainly for most UK businesses, that the answer to that is going to be yes, and you'll want to opt in and file an equivalent UK application. Community registered designs. Very similar situation to trademarks. On the 1st of January, something called a re-registered UK design will be created for every registered community design. Each re-registered UK design will again be put on the UK register. It'll have the same legal status as if it had been applied for and registered under UK law. It'll have the original community design filing date and original priority date, and it will be a fully independent UK design. Again, no application, no fee, no certificate, and again, you'll have the opportunity to opt out, which again, I think it's unlikely that many businesses will choose to opt out. There'll need to be pretty compelling legal reasons, I think, why you would want to do that. And a very similar position again for applications for registered community designs. If you've got an existing application, you'll have 9 months in which to file a UK application for the same protection, which again will be given the same filing date and be effectively the same right. position is slightly more complicated with community unregistered design rights. So it's worth reminding ourselves at this point that community unregistered design rights are very different beasts to UK unregistered design rights, and look much more like a registered design in terms of what they protect, so the scope of their protection, from the UK unregistered design right, which is much more like copyright in industrial designs. And they're also very different in term. So community unregistered design rights are a relatively short-lived right. They last only for a 3-year term, as against the possible 10 or 15 of the UK unregistered design right. So what is the situation is going to be that an existing community unregistered design right will continue to be protected in the UK for the remainder of the 3-year term through what's going to be called a continuing unregistered design. Again, it's going to be worth bearing in mind that we're going to have 2 UK unregistered design rights, which are very different from each other. But yes, your protection will continue. However, new designs launched in the new year, there will be a new UK supplementary unregistered design available in UK law from the 1st of January, which mirrors the community unregistered design right, but is applicable in the UK only. To obtain that new UK supplementary unregistered design, your first disclosure of the design will need to be in the UK. But a first disclosure of a design in the UK won't establish a community unregistered design. So if you have a new product and you launch it in January, you launch it in the UK, you'll obtain, to the extent that that a supplementary unregistered design is available for it, you'll obtain that supplementary unregistered design, but you won't get the community unregistered design. But if your first disclosure is in the EU, then you will get that community unregistered design, but you won't get the UK supplementary unregistered design. So that's the first of the things that I think we think very hard about. If you are in a business which relies on or a community unregistered design right, considering where to launch new products from the 1st of January onwards is going to be an important consideration, because it appears that it's going to be at least very difficult to obtain both UK supplementary unregistered design and a community unregistered design. There is some suggestion that simultaneous launches of products in both the EU and the UK may give rise to a first marketing in both, and that you might get both rights. But I think it's going to be difficult to make that stick, and you'd be relying on how the courts would approach that question. So it's possible, but thought will need to be given to where you want to launch your products if you are intending or wanting to rely on community unregistered design right, or the UK supplementary unregistered design right. So just a very, very quick slide to talk about European patents, because the good news with patents is that European patents are not a community right. They're not a facet of community law. European patents come from the European Patent Convention, and in theory, nothing changes. I'll talk a little bit later in the sort of this horizon scanning piece about what may happen to the Unitary Patent and Unified Patents Court, because those have become a political football, even if again they're not facets of community law. But the patent situation doesn't, in theory at least, change. Copyright. And again, the good news on copyright is that subsistence of copyright should not change. The UK and all other EU member states, the EU 27, will continue to be signatories to the major copyright conventions, which give rise to the fundamentals of copyright law. But you do need to be aware that to the extent that you rely on existing EU cross-border arrangements, they will cease to apply in the EU. What sort of things are we talking about there? Well, the one that might affect most of us is portability of online content. So I don't actually know what's going to happen to Spotify subscriptions, but the concern certainly that my kids have got is that when they next go on holiday to the EU27, their Spotify subscriptions won't work because currently the reliability of something like Spotify across all EU member states is a facet of EU community law, and that portability of online content will cease from the 1st of January unless licensing agreements specify otherwise. Copyright clearance of satellite broadcasting will also change. So if you're receiving European satellite broadcasting, that may not be legal any longer. And actually, reciprocal protection of database rights, which is potentially quite a serious one. Increasingly, technologies are relying on large databases for a lot of AI applications, for instance, and we should be aware that that reciprocal protection of database rights is not something that will continue from the 1st of January. What exactly will happen there is unclear, but if you are a business that relies on databases, you probably need to be thinking about what rights you have, and again, how databases may be shared. And there are various orphan works exemptions. That's works that can't identify authors or what have you, and those exceptions mostly come from community law and will not necessarily be continued in the UK. There is some lack of clarity as to what the law is going to be going forward. A practical step and something you need to think about is representation. So I think most businesses will have representatives that deal with their registered rights, probably in the UK and in the EU. But from the 1st of January, UK attorneys will no longer be able to represent clients on new applications or proceedings at the European Union Intellectual Property Office. Looking at it the other way round, rather unhelpfully, less than 2 months from the date, the UK IPO will say no more than that it's considering making changes to the rules on correspondence addresses for new applications and proceedings at the UK Intellectual Property Office. But there is a strong suggestion that sometime between now and the 1st of January, they will decide that for new applications and proceedings in the UK IPO, you will need a UK correspondence address and a UK representative if you're being represented externally. And that means that community rights owners are going to need representatives in the community, and UK rights owners will need representatives in the UK. So to the extent that you've run on one set of representatives in the past, you need to consider whether they can still fulfill both roles. So exhaustion of rights. At this point, actually, can we have the third poll, please? Great, okay. So for those businesses, exhaustion of rights is important, and it's just a reminder that exhaustion of rights is the legal principle by which a rights owner's rights in a product become, we use the expression, exhausted when that product is marketed by them or with their consent. So if you have a trademark for a product and you sell that product under that trademark in the UK to somebody, that person can then sell it on, and the trademark's still being used in relation to it, but you can't prevent that use using your trademark rights, because when you sold the good, that you exhausted your rights. So currently the position is that within the EU, intellectual property rights are exhausted in the EU when a good is marketed by or with the consent of the rights owner in the EU. Now, that's a facet of EU IP law, where in relation to, say, trademarks or design rights, where they're not community rights, it's a function of UK competition law. So exhaustion applies to patents as it applies to trademarks because of EU competition law. From the beginning of January, from the end of the transition period, the UK has indicated that rights in the UK in a good which are marketed in the community will still be exhausted. So we are going to continue to recognise EU exhaustion. So to the extent that a good has been first marketed in the EU27 state, bought, say, in Spain and imported into the UK, that resale of that good in the UK will not be able to be prevented by an intellectual property right, because, except to the extent that the law currently might enable it to, because it's been repackaged or something. Exhaustion will still apply. So you won't be able to use trademark rights to prevent the resale of goods that you've sold in EU27 states in the UK. However, it is not going to apply in the same way the other way round. So community rights in a good marketed with consent in the UK will not be exhausted. So anybody buying a good in the UK and exporting it to the EU27, where it's been bought, or it's been put on the market in the UK by the rights owner or with the rights owner's consent, the resale of that good in the EU27 will potentially be able to be prevented by the community right that's in that good. So exhaustion is different two ways round, and it looks as if that is going to remain the case, at least in the short term. So looking ahead, what do we need to be aware of? What can we see coming down the line? Well, there are a number of issues that we need to be aware of, and actually, it's been a really interesting few years in copyright law. Many of you may have seen or hopefully read articles by some of my colleagues about this case, Coffermill. But there's a move, or the CJEU has been moving towards an interpretation of copyright law which doesn't allow or recognise the approach taken by a number of member states to copyright law, in which they have identified the kinds of works in which copyright can subsist. So if you look at the UK CDPA, the Copyright Designs and Patents Act, it provides a list of the kinds of work in which copyright can subsist. The move has very much been towards rejecting that. And in Coffermill, the court said member states cannot identify categories of work in which copyright can subsist, and that copyright can subsist in any work which effectively is the innovative results of the intellectual input of its creator. And Coffermill and other cases have also tended to raise a serious question as to whether Section 51 of the Copyright Designs and Patents Act is actually good law under European law. So Section 51 is the section of the CDPA which was introduced in 1988 to remove effectively copyright protection from industrial designs. We had the position before the late 80s where businesses were relying on copyright to prevent the reproduction of their industrial designs, and that reached a head in a case called Leyland and Armstrong, where British Leyland used copyright law to attempt to prevent a third-party manufacturer, Armstrong, from manufacturing spare parts for its cars. And the long and the short of that case was that the then House of Lords came up with a fairly artificial legal construct called derogation from grant to try and prevent copyright being used to restrict the manufacture of spare parts, but it was unclear what the scope of that was. So what Parliament did in 1988 is remove copyright protection from industrial designs under Section 51 and replace it with the UK unregistered design right, which was a shorter lived right and had exceptions which effectively prevented the use of unregistered design right being used to restrict the ability of third parties to manufacture spare parts. And we have relied for 30 odd years on Section 51, but Coffermill had placed a real question mark against whether Section 51 was good law. We're in a position now, obviously, where going forward, the UK courts are to an extent bound by the Coffermill decision, but that less so as we go past the 1st of January. And there are strong suggestions that the government, one of the first intellectual property law, at least, battlegrounds the government may choose to go with to vary from EU law, is that they may pass legislation effectively to repeat Section 51 or to reinforce Section 51, or they may take other steps, effectively encouraging the courts to I say in the slide, to revert to early UK law, but to reinforce and uphold Section 51. It's a really unclear area of law, and it'll be interesting to see what sort of cases we get there, but it's an area that anyone involved in manufacture of spare parts, or who has people manufacturing spare parts for their products who may prefer that that wasn't happening, should keep an eye on, and something we'll come back and address as we start to see some cases coming through. I talked in the previous slide about the unilateral exhaustion regime, which the UK appears to be going to follow. A unilateral exhaustion regime where exhaustion works differently in different directions appears to infringe the provisions of the TRIPS and GATT agreements. So it seems as if it's likely that the UK will be in breach of international law in having unilateral exhaustion regimes. And again, we may expect to see challenges there down the line. What the resolution of that will be is not entirely clear, but it's possible that the exhaustion regime which the UK government intends to adopt, that is, that goods put on the market in the EU27 have rights exhausting them in the UK, that may fall away, I guess, under challenge, but we'll see. Hopefully, in fact, what may happen is that sense will be seen, and we'll have effectively an agreement with the EU to have exhaustion work both ways. And finally, on this slide, in terms of future developments, I mentioned previously the Unitary Patent and the Unified Patents Court. Again, strictly, these aren't an EU issue, and those that have been following these developments. So this is was originally a provision, a proposal to have a unitary patent, which effectively would be a patent which was a single right enforceable throughout the signatory states of the unitary patent, and a unified patents court, so that in the same way that we had with community trademarks and community designs, you can have a single seat of litigation, single action in respect of your unitary patent and enforce patents throughout the member states, in the same way that you could do with an EU trademark or community registered design. It has actually been ratified in a large number of states, but there's a serious question now as to where this is going. I think the European Patent Office is still suggesting that the unitary patent will be introduced in 2022, but there are some serious question marks there. It's become a bit of a political football. The UK has indicated that it's not going to participate anymore, which I think is a great shame, not least because one of the three major courts was going to be in London. And there are political objections to it arising in Germany, which appear more serious than first appeared to be the case. I'm afraid it rather looks as if progress there will be unlikely in the near future. Hi, sorry, I think I'm back in now. Got a couple more questions, but finally on these takeaways. If you're launching new designs, consider very carefully where to do so. Do you want community unregistered design rights or UK supplementary unregistered design rights, or do you want to see if you can get both? And if you are an importer or exporter, think very carefully about the exhaustion regime. If you're buying in the UK and exporting to the EU, you need to look very carefully about that. So we have another question. Given that patents aren't effective, will our UK-based patent attorneys still be able to act for us on European patents and represent you in Munich? The answer to that is yes. Yeah, UK patent attorneys are still entitled to practice in front of the European Patent Office, so you don't need to change question representation with your existing UK patent attorneys. They'll continue to be able to represent you in respect of your European patents. Do we have any further questions? So I've got a question on UK attorneys being able to do EUTM renewals. I believe the answer to that is no, but I'm looking at one of my colleagues for an answer to that one. If you've got EU trademark renewals in early 2021, will you need to renew both marks? Yeah, I think the answer to that is you will need to renew both marks, because from the 1st of January, you'll have 2 separate marks. Yeah, confirmation that the answer is no to the first question. So yeah, for renewals, you're going to need to find European representatives for your EU marks. And yes, you're going to need to renew both marks, which is something you should be preparing for now, because obviously if they are marks that go very early in 2021, you're going to need to get representatives lined up knowing they need to do both. Unless, actually, Richard, is it possible to renew early? I mean, can you renew in December for a mark that's due for renewal in January? That may be a resolution.
Hi.
Hi. So is that right? You could renew the marks early. And
yes.
Yeah. So that probably is something you need to think about. Actually, if you've got marks.
I mean, if it is within the renewal window, I couldn't say off the top of my head how long in advance you can do so. But yeah, if it's due for renewal in January, you can renew in December. Absolutely.
Yeah. Okay. So I think that probably good advice would be, if you've got marks come up for renewal in January, get them renewed in December. But not least because, without wanting to be too cynical, I suspect there's a high likelihood that there will be some difficulty, at least, in getting this thing up and running. A smooth transition on the 1st of January would be, I think, something of a surprise. Okay, so another question. If the comparable UK TM created 1st of January can be revoked if the original EUTM is revoked, how can the comparable UK TM become fixed to UK TM as though you'd registered the UK in the first instance? Well, because in all ways it will be treated as a UK trademark, except that if its parent application, if its parent mark falls away, because it's challenged for grounds that would also be grounds for invalidity in the UK. That's the provision of the law. But in all other ways, it's a separate mark, and it's treated as a separate mark. And I think it's difficult at the moment to foresee the circumstances in which that ground would not be a ground that would apply. I suppose a mark may fall in the EU based solely on use, or on earlier use in another EU territory, in which case the UK mark would probably survive. Yeah, please, Richard.
Yes, so I mean the rule is, if you your registered community design or your EU trademark is registration is the subject of revocation or invalidation proceedings which are pending at the end of the year, wherever that might be. So it could be before the EU IPO or an EU trademark court or a community design court. And after at some point next year, the EU trademark or registered community design is revoked or invalidated. That will also have the effect of killing your comparable UK trademark or your re-registered design in the UK, unless the grounds of revocation or invalidation, as Mark mentioned, would not apply in the UK. So I mean, so for example, if someone is applying to invalidate your EU trademark on the basis that it is descriptive and that succeeds, and that would, unless it was, certainly if it was descriptive in the English language, then it would have the effect of killing your comparable UK trademark. If, however, somebody is applying to invalidate your EU trademark on the basis of a Spanish national registration, and that's then successful, then the UK can ignore that.
Thank you. I should explain for those who don't know Richard. Richard is one of my colleagues in our trademarks team, and has been one of the UK representatives on the International Trademark Association's Brexit task force. So is a fount of knowledge on Brexit and how we've got to the position we're in now. Good. Do we have any further questions? Okay. Fantastic. Thank you very much, everybody, for attending. Before we sign off, just a reminder that we'd like your feedback. What was good? What was bad? How did we do today? Other topics. If you've got any other topics you'd like to hear from us about, please do let us know. And when you end the webinar, you'll get a feedback form. Please complete it. The more we know about how we're doing, the better we can do with these webinars. So on that note, thank you very much for attending, and I will call it a day there. Thank you very much indeed.